Your Honors.
SJC-11216 Commonwealth versus Pacheco.
All right, let's begin. Yes, good morning, counsel.
Good morning, and may it please the court. Paul Rudolph on behalf of Antonio Pacheco, the appellant, and with me is trial counsel Tracy Waltz. Just 2 years ago in Cruz, this court affirmed the will of the voters when you made it clear that in light of the ballot initiative decriminalizing possession of small quantities of marijuana, the police can no longer issue exit orders or search cars based solely on the knowledge that someone inside that car had been smoking marijuana. And yet today, the Commonwealth asks you to rule that the police can legally issue exit orders and search a car, an entire car, including its trunk, so long as there's probable cause to believe that two people together were smoking marijuana inside that car. I'm asking you to reject that attempt to distinguish this case from Cruz, to reaffirm the will of the voters, and to reverse the denial of Mr. Pacheco's motion to suppress for two principal reasons. One, because communal consumption of marijuana does not constitute the crime of distribution. And two, even if it does, the permissible scope of a car search based on probable cause to believe people are smoking marijuana together in a car does not extend to the trunk.
Can you tell me about communal consumption? Does that apply to alcohol? If someone buys a jug and they share it with several people, is that communal consumption? And
Well, of course, there is no crime of distribution of alcohol.
I'm trying to think of an analogy. Cocaine.
An analogy that I would draw, which I think really shows a distinction between the conduct of sharing for communal consumption and distribution, if we can take it out of the drug context, is if a group of people go out to dinner and at the end of the meal, only one person orders dessert, but says the rest of you can have a bite. I don't think anybody would say that that person had just distributed his creme brulee or had delivered or transferred, which is the language of the distribution definition under 94C Section 1. We would say that person shared his dessert.
What about my hypothetical? Someone says I have a bag of cocaine and they share it with everybody can have a snort.
Right. So I think that that's an important question, Justice Ireland, because what I would say is that even before decriminalization, it was far from clear that that type of sharing for communal consumption constituted distribution. Certainly, neither this court—
As opposed to joint possession.
That's exactly right. Neither this court nor the legislature had ever adopted as broad a definition of distribution as the Commonwealth asks you today to adopt. This court had certainly never said two people passing a joint are committing the crime of distribution. And in fact, in Commonwealth versus Johnson, this court recognized that physically passing drugs to someone, at least in one particular context, is possession and not distribution. The statutory language in 94C Section 1 doesn't include the word sharing, and as I said a moment ago, I don't think any common sense use of those words really applies to the distinct conduct of sharing for communal consumption, and I think that the dessert example really gets to that. So even before decriminalization, it was far from clear that this type of conduct fell within the distribution statute. And then, of course, in 2008, along comes the ballot initiative, overwhelmingly approved by the voters for the purpose of accomplishing two explicit objectives, which were articulated in the information guide and recognized by this court in Cruz, and both of which would be significantly undermined if this court concludes that communal users of marijuana are excluded from the protection of the decriminalization statute. The first explicit purpose was to shield users of marijuana from criminal sanctions and the harsh, sometimes lifelong collateral consequences that attach to a criminal conviction. And clearly, this was intended to protect users.
Small amounts.
Of small amounts, absolutely. But we weren't decriminalizing possession so that somebody could hang a marijuana butt on their wall and call it art. It was so that people could smoke marijuana in small quantities without fear of criminal prosecution and without suffering those severe consequences. And it is widely known and even well documented, as pointed out at page, I believe it's page 14 of the ACLU's amicus brief when they cite to the United States Department of Health and Human Services annual drug survey, that people who use marijuana use it communally. More often than not, the users of marijuana share their marijuana communally. And as I said, that is widely known. And certainly the voters understood that. And so it would be, I think, absurd to think that the voters only intended to protect the probably rare marijuana users.
On the analogy, I've been thinking about it and how many, wouldn't normally bring it in, except this is the only way I have for conveying what I'm going to ask, and that is seeing in the movies how people put this line of cocaine and then more than one person, and there's no exchange of anything, go up and snort this line. Are you suggesting that, and I'm trying to think through our decisional law, that we've ever said that amounts to distribution. So would that be a sharing, like a sharing a joint, as compared to a distribution, which would be giving somebody a baggie with a rock in it? Here you go do whatever you want to with it. Is that?
I think there would really be a due process problem with saying that conduct constituted distribution, because the language of the distribution statute, a common sense application of that language, doesn't unambiguously encompass that type of sharing conduct. But when we're talking about marijuana, we have something even clearer, which is the ballot initiative, in which the voters expressed an intention to accomplish these two purposes, and you would undermine those purposes. The second I mentioned the first purpose, which is to protect people who use small quantities of marijuana. The second purpose being that to limit police involvement vis-a-vis marijuana users in order to free up those resources for the investigation of more serious criminal conduct.
Yeah. May I ask you?
Go ahead.
Sorry,
Go
Jeff.
ahead. No, go ahead.
Has any other jurisdiction addressed the issue of communal consumption?
In the ACLU's brief, they talk about the case, the state of the law in other jurisdictions, and it does appear that in the majority of jurisdictions that have decriminalized, this type of sharing is not considered distribution. I can't cite to the exact page in their brief where they go through those the law in other jurisdictions.
So I recall correctly that with respect to some of those, at least it's in the statute that it's for consideration, or is it decisional interpretation?
I would agree that I believe in most of those jurisdictions it is statutory. But again, we do have the decriminalization statute here designed to accomplish these purposes. And
let me ask you this. So if you give somebody a joint for later use, that's distribution, but if you smoke it together, that's joint possession, so to speak?
I would agree with that. I mean, I think that if you wrapped it up in in red and green packaging and said, "Here's your Christmas present," that is distribution. I mean, I acknowledge that this court in Kiefner said it doesn't have to be for sale. So there is some, if you give a gift, or maybe the sort of stereotypical after-school special where the drug dealer is handing out free bags of marijuana to try to drum up customers, that would be distribution. But people smoking marijuana together in a car is not distribution.
If I could turn you back to the facts of this particular case in terms of what would be appropriate. Okay, so you have a police officer coming upon a car parked in a park which is closed. The engine's running, so it's being operated. The car is being operated, correct?
Under our law, that's correct. Yes.
Okay. And he stops the car, appropriately so, and smells the burnt smell of marijuana, and asks whether they've been smoking. And the driver, among others, says yes, correct?
Actually, he couldn't specify who said yes. He said more than one person said yes, and when asked to specify, he said, I I can't.
Okay, but probably he could have inferred adoption, that he could have inferred that the driver was among those who were sharing.
I don't agree with that. I don't think there was
Okay.
any evidence that the driver was sharing.
Let's assume you had a case in which that was clearer.
Okay.
Okay. Appropriate at that time, I would think, for the officer to explore the possibility that he was operating under the influence. Would it not be? Would it be permissible then for him to do a sobriety check?
I would say that if the driver had admitted that she was smoking, the car was being operated, that's reasonable suspicion, and the officer could take steps consistent with
driver
reasonable
wouldn't have
suspicion.
to admit for reasonable suspicion. The very fact that the driver would have to admit they were smoking before there was reasonable suspicion to ask them to get out of the car and do a sobriety test?
No, I think that there would have to be some indicia, some indicia that the driver had smoked marijuana. I don't.
There's smoke coming out of the car.
There's 5 people in the car. I don't think.
Parked at night in a closed park, step out of the car or do a sobriety test. Let me see. You're sitting in a moving car. That's not reasonable suspicion?
I would disagree that that's reasonable suspicion, but in this particular case, it really doesn't matter because it went way beyond
Right,
that.
well, that's what I'm trying to. I just want to play it out. So the officer acting correctly, and we can debate whether it's reasonable suspicion. Let's for the matter assume it is. Okay, could do a sobriety check, evaluate whether or not the person is driving while impaired, and if there's no indication of that, could issue a citation, arguably for the use of marijuana, and then go away. That's what an appropriate police officer would do.
I would agree.
Okay. Any circumstance in which, with regard to an issue of impairment, you could get to the trunk?
With regard to impairment of the driver, yeah, I mean, if nobody else, if they were going to tow the car.
So that would be a search of the car pursuant to the inventory.
An inventory search.
Okay.
And that often happens in those circumstances. But here, and this gets to the second issue, which is the scope of the search. Here, there was nothing indicating that the driver was impaired. There were no arrests made. There was just evidence that somebody or maybe more than one person had been smoking marijuana, and then they pointed out that there was a very small, a partial ounce, as the judge found, bag of marijuana where the occupant said, "There's the marijuana." The officer found it exactly where that individual indicated it would be found, and then the officer at that point certainly exceeded the permissible scope of his authority by going into the trunk. The Commonwealth tries to get around this by essentially taking this kind of categorical approach to defining the scope of a lawful scope of a search by saying it's defined by basically the title of the crime being investigated. They're investigating distribution. Therefore, they can search the entire car. But neither this court, as in Cast, or the U.S. Supreme Court, as in Ross, has ever taken a categorical approach. It's a fact-based approach. What are the circumstances that the officer faced, and which particular locations do those circumstances give probable cause to believe the object of the search will be found? There's a vast difference between somebody who is distributing marijuana by driving around in their vehicle, selling bags of marijuana out of the car, and if it is distribution, people smoking marijuana together in the car. Those are different factually.
Garden makes that point.
That's exactly right. I mean, Garden says the fact that there was probable cause to believe somebody had been smoking marijuana in the car did not justify a search of the trunk. And the Commonwealth points to some language in Garden in which this court said, in that case, there was just the odor of marijuana, and this court said, had the police found a marijuana, even a small amount, then they might have been allowed to search the trunk. That was clearly dicta in Garden, and it was also very conditional. Had they found it, they might have been able to search the trunk. Well, that's true, depending upon what other circumstances were present. If there were circumstances that gave rise to probable cause to believe there was more marijuana stashed in the trunk, then they could search it. But in this case, there wasn't anything. I mean, they also rely on Cast, but Cast is very different because in Cast, it wasn't the fact that they were investigating the crime called distribution of cocaine that allowed the trunk search. It were the circumstances, the facts. They had arranged the delivery of cocaine from somebody in Connecticut to Massachusetts, and then they observe that person go to the car, open the trunk, put a suitcase in the trunk, get in the car, and then drive that route from Connecticut to Massachusetts. So yeah, obviously under those circumstances, there was probable cause to believe cocaine would be found in the trunk. In this case, the mere fact that people are smoking marijuana in the car, particularly after decriminalization, as this court noted in a footnote in Cruz, where people are more likely to take care to possess an ounce or less, there was not probable cause to believe marijuana would be found in the trunk. I see that my time is up. Thank you.
Thank you.
Good morning. May it please the court, Ron DeRosa on behalf of the Commonwealth. While there were other reasons for the exit order, there were 3 crimes the exit orders were based on in this case, or could have been based on. I would like to focus on what the court has already focused on, which is whether the sharing, whether the officer had at least reasonable suspicion at the time of the exit order, whether the occupants of the car were sharing marijuana and thereby committing the crime of distribution.
Okay, you say in your brief, you sort of incorporate, this isn't what you were talking about, but the judge didn't find anything about their being intoxicated, and you make quite a bit about that.
Well, she made no findings one way or the other. I would
Well,
suggest that
she
you
heard the
can.
evidence, and she found a lot of specific facts, and she didn't find that.
Well, I would suggest you, given her findings of fact, you could imply that she credited the officer's testimony. There was nothing that the officer testified to that she found hadn't happened. The officer, unlike the Daniel case before this court, at least as to the OUI basis, was clear that once he pulled up to the car and the odor of marijuana was coming out, he, and given the admissions to smoking and the fact that there was admissions that there was more marijuana in the car, and he had also testified, he wasn't able to during his testimony specify which individual it was, but he saw signs of intoxication from occupants of the vehicle.
But you let her drive off.
He did, and I would suggest that. But when at the point he asked her out of the car, what he did was reasonable, given what the facts he had before him at that time. But back to the distribution issue, I differ with Mr. Rudolph in the sense that I think the Johnson case from 1992 would suggest that sharing of any controlled substance at that time, before decriminalization, amounted to distribution. The definition of joint possession it's talking about there is how it defines joint possession is where individuals, it's very narrowly tailored to where individuals simultaneously and jointly acquire the controlled substance. That's not what we have here.
Well, we don't know. We don't know.
Well, but now we're back to we're on a probable cause standard, Your Honor. He doesn't know what he has at that point, but he knows he has probable cause that these individuals are sharing the marijuana at that point, which was a fact the judge did credit, that they were sharing, that the inference was reasonable that they were sharing the marijuana. So I would suggest that had this case happened before decriminalization, they could have been charged with distribution, particularly given the Johnson case, the jury instruction this court approved in the Johnson case, as well as the Lawrence case, which the appeals court specifically said the sharing of marijuana amounts to distribution.
Do you attach any significance to the fact that the voters spoke in the ballot initiative?
Well, I attach the significance to the fact that they spoke about the possession of marijuana. That question was very narrowly tailored to talk. The voters thought they were voting on the possession of less than an ounce. In fact, they were specifically told that a yes vote on that question would not pertain to the selling, manufacturing, or trafficking of marijuana. As this court's already found, the voters did not amend the distribution statute in any way when they passed the question. So what was before the voters at the time was possession of less than an ounce. Anything more...
An ounce or less.
An ounce or less. This court cannot imply anything more from the language of the question that has to do with the distribution statute of marijuana.
But here, if each of the 5 of them, well, let's exclude the driver to make it a less complicated point. If each of the 4 occupants of the car had their own joint,
Yes,
and they were obviously smoking their own joint,
if on those limited...
who knows who gave it to them or provided them, but that's what the police officer comes upon. 4 of them with their own joint. There's not a sharing issue. There's not a distribution issue, right?
Well, obviously, those facts are different, but in those limited facts, I would suggest there may have to be something more in order for probable cause. Here, what he did was reasonable, given the facts as he saw them. He comes upon the 5 individuals in the car. The smoke comes out right at him.
But he doesn't see any of them smoking anything.
He sees movement in the car before.
Right, but he doesn't see if there's 1 joint or 4 joints.
I believe.
He doesn't see any joints.
No, his testimony was that, given the strength of the odor that came, it was apparent to him, it was apparent to him they had just smoked marijuana, and the fact that he had several yeses from inside the car, several admissions to smoking marijuana while inside the car.
And somebody saying there's still more.
And someone says there's still more, yes. So, but given those facts, the fact that there's 5 of them.
I guess
and
I
the
just
fact that
don't see why sharing is a more reasonable inference than individual consumption when you don't see anything.
Well, we're talking about reasonable inferences, and again, the judge credited it, and this court would have to find that that fact was clearly erroneous, which I suggest it's not, given the facts before the officer at the time. He also had the fact that the windows were fogged up. And so based at that time is when he orders them all out. He pat-frisks them all and finds nothing, and then while he's pat-frisking them, one of the passengers says to him, there's a bag right there that's on the ground. So he goes and searches the car, sees the 1 bag. At that point, it certainly reinforces the fact that there's 1 bag with a partial ounce in it. Would reinforce it would certainly give him probable cause to believe that they were sharing the marijuana, and would give
But no,
him.
that all it does is gives probable cause to the idea that, that marijuana was smoked.
At that point, when he sees the bag of the partial ounce, I would suggest it even reinforces the inference that the people in the car were sharing the marijuana. So at that point, he's justified in searching the rest of the car for evidence of the crime of distribution.
Mr. DeRosa, when you say sharing, do you mean passing a cigarette?
I would suggest under this court's precedent, the Johnson case specifically, all forms of this court has held, with regard to controlled substances, all forms of physical transfer amount to distribution.
Now, what if there was 1 pipe and 3 people were sitting around and somebody was smoking the pipe, put the pipe down, then the second person picked it up? It wasn't passed from one to another. Or if there were a water pipe that had 3 stems on it and people were smoking a legal amount out of the water pipe. Is that distribution?
Again, different from the facts of this, whether it's probable cause for distribution.
No, is it distribution?
I would suggest that would be a jury question, Your Honor, because in this case we're talking about.
So it is distribution.
It could be
Jury
distribution.
question
It could be distribution. Presumably, they'd be instructed as to what possession means and what distribution means, and it would be up for them. What we're talking about here is an officer's ability to search based on probable cause of the crime of distribution.
So let's agree that technically the passing of a lit marijuana cigarette between 2 people who are smoking it is a transfer and technically a distribution. In your experience, has there ever been a prosecution for distribution based on the sharing of a marijuana cigarette?
No, not.
And so when the voters passed the referendum saying we are decriminalizing the possession of small amounts of marijuana, do you think they had in mind the passing and sharing of a joint as possession or distribution?
Frankly, Your Honor, I don't know what they thought. I know they were told that it wouldn't have any, they're presumed to know that.
Never having been a prosecution for distribution for 2 people sharing a marijuana cigarette, do you think the voters had in mind, well, now that's the avenue in which this kind of conduct will be prosecuted and in which resources of the police department will be directed?
I don't know what the voters thought, Your Honor.
Is it reasonable that the voters would have thought
It is,
that?
but the problem is that because the question that was before them was ambiguous, that this court cannot repeal an existing law because of the ambiguity that was that the law presented. If they had explicitly said, we wouldn't be. First of all, it was a ballot initiative, so we don't have any legislative history to look at. All we have is what was presented to the voters at the time. So if it was explicitly said to the voters, instead of the language being selling, manufacturing, or trafficking, this would also allow, we're also asking to amend the distribution statute to allow for the sharing of marijuana then we'd know what the voters knew. But because it's ambiguous, because of the way the question and the statute was drafted, and because there was no amendment to the distribution statute, my point is that the distribution statute remains intact the way it was before decriminalization.
Don't you think that the result is somewhat absurd? If you have 4 people sitting in a car and have 4 joints, each of them could get fined $100 for what they've done. If it is 1 joint that the 4 of them share, they could each get 2 years in prison.
Personally, yes.
Distribution.
Personally, yes. But given what the laws say, Your Honor, it wasn't created. The fact that someone could be charged with distribution for sharing marijuana wasn't created by decriminalization. That possibility was there before decriminalization.
That's a question. I mean,
Well, I would suggest, given this court's precedent and given the appeals court precedent, that's what the law was at the time
Now,
decriminalization was passed.
what meaning do we give to the title of the act? An act establishing a sensible state marijuana policy. You've just answered Justice Lenk and said that your interpretation would be absurd. I mean, you may say that's what the law is, but that's absurd, thus not sensible. Shouldn't we interpret a sensible state marijuana policy to be sensible?
Well, my personal opinion doesn't set the policy
Well,
for
I
the
understand,
Commonwealth.
but you're probably in the
legislature and the
mainstream.
laws of the Commonwealth set what the policy is, Your Honor. So,
Right, but I guess the broader point is, should we not take that word sensible state marijuana policy and give it meaning?
well, it has meaning in the sense that the collateral consequences and strictly possession of less than an ounce of marijuana was decriminalized, which was, according to what was the language given to the voters, aimed at the collateral consequences of college admissions, that sort of thing. I would suggest that it was given meaning by the sensible part of that title was given meaning by that.
And so, according to that, then you could say that a DA could interpret this to say, well, before we would have prosecuted that as criminal possession, and now we don't have that, but now we can prosecute it as criminal distribution with higher penalties and maybe add on the school zone. And that's what the voters thought they were doing?
Well, the voters were presumed to know what the law was. So again, the fact that the second scenario you just presented could have happened wasn't created by decriminalization. My argument is that possibility existed before. So therefore, the Decriminalization Act really didn't speak to the distribution statute.
And what meaning do we give that when the Act spoke about what it did not cover, it spoke about selling, but not about sharing?
Well, this court has already determined that those weren't an exhaustive, that wasn't an
Right,
exhaustive
so it includes
list.
distribution.
And because distribution, the way it was, my argument is the way it was defined at the time under this court's precedent, sharing remains distribution just as it did at the time of decriminalization. I'm happy to address any further questions of the court.
Well, I guess the final question is, how do you get into the trunk?
yeah.
Well, at that point, Your Honor, assuming that sharing amounts to distribution, he has probable cause that a crime has been committed. He finds the marijuana in the car. He then has probable cause to search the entire car under the motor vehicle exception for further evidence of distribution.
But we're thinking about distribution in the context of the initiative having passed. And so there is this bright line about 1 ounce or less, right? You have a bunch of, how old were these 5 people?
17 to 19 type of age, Your Honor.
A bunch of young people in a car saying they've been smoking marijuana. Somebody says there's a small amount under the pad in the back of the driver's seat, which he says is a partial ounce. Where do you, in that context, on those facts, what about that gets you to the trunk?
Well, just simply the fact that numerous precedent going back has held that the discovery of some controlled substances allows for the search of more. Now,
But as Mr. Rudolph said, it is pretty contextual. That's the way we look at it.
it is, Your Honor, but in the sense that the officer doesn't know what he has at that point when he searches the car. The dealer may have driven, someone that was providing the
Dealer?
marijuana, someone that may have, he doesn't know what he has at that point. I mean, he knows he has people smoking marijuana in the car. What if the dealer showed up and said, you guys want to try this out, and passed it around, and then from there. So he knows that one person has brought marijuana to distribute at that point.
Know that. He doesn't know anything.
Well, this is the point. That's why, again, we're talking about a probable cause standard. And that's why, the Lattimore standard is there for a reason where this
But
case
if it
go
was
to
just
trial.
one person and the officer saw exactly the same amount of marijuana, he wouldn't be able to search, would he?
I'm sorry, I didn't,
One person,
in the car smoking
Yeah.
marijuana?
yeah.
Not for probable cause of distribution, whether there may be other indicia of OUI, with the car running.
Right, if the car wasn't running, no search.
Well, even if there was an OUI, I mean, if there was an OUI, you certainly, probable cause to believe the person was operating under the influence of marijuana, you would certainly, I think, be able to search the passenger cab for evidence of the crime, but the trunk?
If once the substance that they're deemed to be or suspected of being under the influence of is found in the car, I would suggest you could search the trunk for further evidence of.
For evidence of operating under the influence or for evidence of another crime?
Operating under the influence.
Okay.
All right,
In
thank you
that
very
scenario.
much.
Thank you.